Hi, good afternoon, everyone. Welcome to Clocking In with PilieroMazza. I'm Sarah Nash, partner in our Labor and Employment Group, and here is Nicole Atala.
Hi, everyone.
Today, we are eager to talk to you about a new final rule from DOL. It came out a couple weeks ago, and it is the FLSA wage threshold increases. So Nicole, you have been looking very carefully at these changes, which, as I understand it, are scheduled to go into effect very soon. Can you tell us a little bit of what we're looking at?
Right. So the Department of Labor has long wanted to increase the salary basis test for those people that are exempt from overtime. So if you recall, if you want to classify somebody exempt and not pay them overtime, you have to meet both a salary basis threshold and you have to meet their duties test. And the duties test can vary depending on which exemption you're trying to take advantage of. But the threshold was set pretty low for a number of years. The Obama administration tried to increase it to over $60,000 a year, I think was the threshold. That kind of got smacked down by the courts. So they implemented a lower threshold at like $655 a week. That's the current threshold for it. So you have to pay on a salary basis, that threshold. But effective in July 1st, 2024, the Department of Labor is going to increase that threshold to $844 a week. But the funny thing is, it doesn't stop there.
There's more?
It doesn't stop there. Then on January 1st of 2025, that threshold is going to go up again, 1,128. It's such a weird number. It's not going to be easy to remember. So effective July 1st, $844 or $43,888. January 1st, $1,128. I'm really struggling with this number. I'm not going to
These numbers, this is why I'm glad you're doing this, because I would have been, I can't even read numbers, so it would have been a disaster.
If you want to think about this in terms of an annual salary, it's $58,656 per year. So that's a significant jump from the salary basis test that is in place now. There are a couple of other unique features this time that we didn't see under the Obama administration. One of those is that the amounts will automatically increase based on I think it's Bureau of Labor Statistics data every 3 years. So they're going to basically take statistical data on the labor market and increase the salary basis test every 3 years based on, basically what inflation is doing. So they're going to, that's very unique to wage and hour law. We've seen it on the federal government contractor side with the minimum wage rules. That's kind of happening on the minimum wage rules. So they've been clearly trying to test it out. But it kind of makes sense based on the fact that Congress is not increasing the minimum wage or salary basis test at all by congressional legislation. And it's been sitting at such a low threshold that effectively what's happening is that companies and contractors that do not understand what the duties test is, which is frankly the harder of the test to meet, they'll just say, well, I'm paying above the salary basis test, so it should be okay. And so in order to combat that, they're trying to increase that test. And I know, Sarah, we've seen that across the board on a number of occasions.
For sure. I have a couple questions for you. First, why the acrobatics here? Why are they making us do increases in July, increases in January, and then keeping track every 3 years thereafter? It just sounds really complicated.
Well, my guess is that they're trying to beat the case they lost in Texas under the Obama administration. So basically what happened, and I'm not going to quote from the case or anything and bore you, but the court there said the jump is just too high. And we think that if the salary jumps too high, you probably should have gotten congressional buy-in on this. And they really didn't. They really were talking about the authority of the executive branch. We've seen a lot of attacks on the authority of the executive branch during this administration. And they really were just trying to say, I almost felt like I'll know it if I see it, and that's too high. And the Obama administration decided not to appeal that case. I think they started an appeal, and then it was getting close to election time, so they just decided, you know what, we're going to go back to the drawing board. We'll instead of appealing that case, we'll decrease the amount to some more reasonable amount and see if we get a challenge. And that challenge, you know, that was not challenged in the same way. I think kind of business said, okay, this is an okay compromise. We're not going to fight this too hard. But now, fast forward, I don't know, 6 years or so. I don't know. I can't even remember exactly the date, but a number of years, the Biden administration really wants to get those wages higher again for salaried individuals and is trying to figure out where's that line? Where's that threshold? How far can we go? So if they do this jump in July and then a jump in January, maybe they can slowly get there without having to, you know, navigate that decision out of the Fifth Circuit.
Mm-hmm. Complicated. So it's lawyers' fault, basically, that we have to jump through all these hoops. So we're about 5 weeks out from July 1. What should companies be doing to prepare for this change, if anything?
Right. So the one thing that, I mean, there are a number of things, not one thing, a number of things that you really need to be doing now. The first thing I would tell contractors not to do is rush to implement a change to the salary basis test. It's more like prepare and then wait for July 1st and roll it out. Because we could see a state of this rule at the 11th hour, just like we did during the Obama administration. And we had a number of clients that went ahead, announced to their exempt staff that they were going to make changes to the salary basis test, created all these wage compression issues, because if I'm going to pay this guy or lady, you know, $844 a week, now I've got to like raise the people.
Make sure their managers are earning more, yeah.
And those things you are not going to get equitable adjustments for or price adjustments for. It's going to fall on your shoulders to increase or to deal with any of those downstream effects, right? Or even the direct effect. You know, you're not going to really be able to get adjustments to your contract price for this because you're not being forced to do it. You can always convert them to hourly, right? So the first thing you want to do is really just assess your exempt workforce, right? Number one, are the people you have classified as exempt truly exempt? Do they meet the salary basis test? When was the last time you looked to see if they meet the salary basis test, right? Because the Department of Labor doesn't really care about their salary or the job description. They care about what people are doing every day. So just as a standard practice, you should be auditing the, you know, randomly auditing positions on occasion to make sure they still qualify for the exemption. So once you kind of determine, yes, we think everybody is in the right general category based on the duties test, then you look to see how many people will be impacted by the salary basis test, right? How many people will you have to raise their wages in order to meet the salary basis test? What's going to be the downstream cost for those wage compression issues? And then you're going to have to make a decision as to whether you want to keep them as exempt or convert them to hourly. There is no restriction on converting people to hourly. You can always make somebody an hourly employee, right? You just can't make someone salaried that doesn't pass the test. So that's really those couple of things you need to do. Make some organizational decisions about what you're going to do if it is implemented, and have your communication ready for employees. For example, do you need to, if you're going to convert a whole bunch of people to non-exempt status, and you've never really had a lot of non-exempt staff before, do you need a timekeeping system? Are you working on DOD contracts and now you need to make sure you have those people in a DCAA approved timekeeping system? Clock in and clock out. You like those kinds of tactical.
And monitoring overtime, right? So like if nobody's had to worry about overtime before, but now you've got a bunch of non-exempt folks, suddenly it's a much bigger impact on your bottom line.
And Sarah, you know what happens if you've misclassified somebody as exempt. Sarah's worked on a lot of these like cases where there's been a misclassification of somebody as exempt when they should be non-exempt, and the person claims they've worked all this overtime. And it can make it really expensive.
Really messy, yes, and expensive, because the benefit of the doubt will always go to the employee if you don't have the records to back it up. Oh, yeah, memories. So there you have it. That's the update on the FLSA final rule. We will let you know if we see any legal challenges out there. There hasn't been anything yet that I'm aware of, though there have been some petitions to DOL to kick the can down the road a bit and maybe delay that July 1st deadline. Not a lot of hope that that will happen, but again, we'll let you know if it does.
Yeah. The one thing we should note is that if you are an employer that has employees subject to the Service Contract Act, this is really going to have an impact on how you manage those contracts. And so because you're exempt folks, there may not be categories for them as non-exempt personnel. And once they're non-exempt, they're subject to the SCA. So
conformances.
Yeah, so we're going to need to work through that as well. And if anybody needs to try to figure out how to classify people or aren't comfortable with how they've classified people, we do have a couple of worksheets that we can send you to help you out. We can look at the difficult ones and kind of help you muddle through it. But just reach out to us if you're not confident in that regard. All right. Thanks, everyone.